Your conference will begin when the chairperson arrives. Please wait. You will now be placed into conference. There are 10 participants in the conference.
Okay, we ready? All right, good morning, everybody. This is day 3 of the Alaska Marijuana Control Board meeting in Anchorage. I'm Mark Springer, the chairman. I think everybody is here. Brandon beat me in here this morning because I was in the coffee line. So, Sarah, if you could call the roll, please.
Mark Springer.
Here.
Brandon Emmett.
Here.
Nick Miller.
Here.
Lauren.
Welcome to the GCI. Thank you. Please stand by. You are being placed into conference in listen-only mode. There. Welcome to the GCI Conference Center. Please enter your access code followed by the pound sign. Thank you. Please stand by. You are being placed into conference in listen-only mode. There are 19 participants in the conference.
Within the past 6 months, and that is a slightly different situation, but it remains a concern. So as I stated in my memo, the allowance for personal manufacturing of marijuana products is not straightforward in statute, and that may be something that needs the attention of the board in August as making a recommendation to the legislature. But despite the ambiguity in 1738 and between 1738 and AS 1171, to manufacture within a premises that is shortly coming before the board for licensing review using equipment intended for commercial use, to me it's very hard to argue that that's personal use. So we don't recommend denial of this license, although I will note that there is a municipal protest, so I would recommend that should the board consider this for licensing, it would be upholding of the protest with a certain period of abeyance. But we do recommend that the board consider a civil fine for bringing marijuana onto a premises before it's licensed.
Through the chair, Director McConnell. So I don't think I'm as familiar as I should be with what's allowable in AS 17.38 as far as personal use marijuana is concerned. But I know you can make extracts in your home, but I'm not incredibly certain on the language as to where else personal use is allowable. Can you
I'll try
clear
to
it up for me a little bit here?
I'll try. It's confusing. So, and I may look to Ms. Milks for some assistance as well. So 1738-020-1 says that people over 21 can possess, use, display, purchase, or transport marijuana accessories or 1 ounce or less of marijuana. And then 2 says possessing, growing, processing, or transporting not more than 6 marijuana plants and possession of the marijuana produced by the plants on the premises where the plants were grown is allowed. So you get to what is the definition of processing? Well, processing is defined in our regulations specific to the meaning in our regulations. So we have 2 sections of definitions. We have a section that applies that defines terms that are both in statute and regulations, and then a section that defines terms that are only in regulations. Processing is defined in the section that is only for our regulations as harvesting, curing, drying, or trimming, because manufacturing is what the term we use for creating marijuana products through some sort of extraction process. And our thoughts on why that term wasn't defined for both statute and regulation is because the word process or processing is also used for the activity that we do with applications. We process applications. And the other thing is, it's unclear whether those other types of things are supposed to also apply to where the plants were grown. I mean, clearly that doesn't make sense when you talk about transporting. But possessing, growing, processing, and possession of the marijuana produced by those plants on the premises where the plants were grown. So that's clearly not the situation here.
Thank you.
If my memory serves me, and since sometimes I can't remember the names of all the board members during a vote, I won't necessarily trust it, but I seem to recall that we have inquired of manufacturers, particularly edible manufacturers, well, have you tried that recipe out yet? And, you know, with the thought that is what you're showing us in your application a photograph of something you got off the internet, or is that something that you made? And notwithstanding, either a positive or a negative answer, I certainly never felt any sort of concern that if somebody answered affirmatively and said, "Oh yeah, we made a batch of these candies, and this is what they look like, and we did it in the kitchen that we're applying for a license for," I never considered that would be any sort of an illegal act. And I'll ask Ms. Milks to at least ponder what principle or what legal principle would be applied to discern an illegal act where A, there doesn't appear to be any particular controlling legislation or regulation until a facility is licensed. Once it gets licensed, the things that go on in there are under our purview. But I don't know how much product was manufactured during these pictures. If we get a motion to consider a fine, then I guess it would be appropriate to ask those sort of questions. But we know that people are, prior to receiving their licenses, cultivators have plants on the premises. We can infer that some of them have cultivated plants on their own to bring those strains in. And if I had invested X amount of money in what I euphemistically call a refinery, I would want to test it out before I went online. I may realize, either I don't know how to do this, or something's really wrong here, and I need to invest more money and fix it. Maybe I got to wait to get my license. I will agree that sometimes there is such a thing as bad publicity. But that's my principal question is, would the board have a leg to stand on to apply a fine for something that was done that, at least up to the point that he starts cooking it, is legal, possession of marijuana. The consumption of marijuana. If it was something somebody was doing in their own private garage, we wouldn't have, you know, if they're not selling it, we wouldn't have a jurisdiction. So that's kind of the crux of my question there. And if you've got a quick answer for us, that'd be great, and then we can move on and see what we would like to do with the director's recommendation.
Thank you, Mr. Chair. Request to ponder accepted. I don't have a quick, definitive answer for you. What he's done is not specifically or clearly prohibited, but it is something that I think the board probably should put some thought into and address in regulation further. So I think the director's points are also very well taken here.
And Mr. Chair, I would add that we don't permit people to bring plants onto premises before the board has approved it. Now, of course, they bring it on before the inspection, but not before approval or even once they've come out of delegated status.
Mr. Chair, we hear from the applicant and his counsel.
If you care to, before we make a motion, go right ahead.
Thank you. For the record, I'm Jason Brandeis. I'm the attorney for Cold Creek Extracts, and I'm here with Cade Insco, who is the potential licensee. And I know you have a handout that we provided yesterday, and I've got another handout that I'd like to distribute. I think I've got enough copies for everyone. Cade, would you pass that to I want to just start by mentioning a few things, and one is that the information that we provided in our response to the director's memo was intended to try to establish Mr. Insco's state of mind, right? That he was not he was acting on advice that he believed was correct, and that he did not have any commercial intent. And I think from what I'm hearing so far, it seems like the board understands that. But as we were meeting with enforcement and talking through these issues, the idea that there is some ambiguity in the statutes became very clear, and the director enunciated that before. One of the things that Director McConnell mentioned is a term that I got a little caught up with as well as I was working through this, and that is this question about processing. Right? What is processing? You can read 1738-020 subsection 2, which you have in front of you now, and it does say that you can that processing is permitted for personal use. But I want to go back to subsection 1, 1738-0201, which says that personal use includes possessing, using, displaying, purchasing, or transporting marijuana accessories. So using marijuana accessories. And if you look to the definition of marijuana accessories, which is on page 2 of the handout, it's 1738-911. Marijuana accessories means any equipment, products, or materials of any kind which are used, I'll skip a bunch of these words, and it gets down to intended for use for manufacturing. So individuals are permitted to possess and use marijuana accessories, which are equipment used for manufacturing. And then if you look at the definition of manufacture, which is on page 3 of the handout, it basically explains the process of extraction. So I think there's a strong argument to make that 1738-0201 permits the use of equipment for manufacturing marijuana. And I think there's a variety of different ways that this issue is in a little bit of a gray area. You have someone who is an intended licensee and is in the application process but is not yet in delegated status. And I know that when the board puts someone in delegated status, you essentially treat them as a licensee. But how someone is treated who is pending licensure, I think is still a little bit confusing for a lot of people and a lot of potential licensees. And in this case in particular, I feel like Cold Creek Extracts has kind of gotten caught in the middle here. We have activity that I think is arguably covered by the personal use statute because this is a licensee that is pending an application. And then there are the other questions about testing the equipment and doing things that are essentially required in order to produce the materials needed for the application. So I think when you consider the sort of the totality of the circumstances and look at this situation as a whole, we have a situation where, as the director pointed out, there is ambiguity in the statutes and some lack of clarity. We don't have any evidence of commercial activity or intent, and you have someone who was relying in good faith on previous information that may or may not be the position of the board. So I think when you consider all of that, we certainly have a situation where this is ripe for, I think, guidance from the board to make a clearer statement to applicants and potential licensees about what is permitted when you're going through the licensing process. But we don't think that the $5,000 fine is justified considering the ambiguity in the statutes and the arguments that can be made to show that the applicant's activities were within the bounds of the law.
Thank you, Mr. Chair.
Yes, sir.
I understand all that, and the part that makes me not want to accept that argument is that this is not a new applicant. As I read the MJOO document, he currently is, I assume, some form of transfer documents are under review for an extract product manufacturer, for a retail store, and I think the other license number came up at, and the retail store is active, the manufacturer is active, and the cultivation is delegated. So we're not talking about somebody that does not have any experience manufacturing. Kate has been before us before. He's given some great explanations of products. I mean, this is not a novice manufacturer, and a current licensee. And to use the argument that, well, you know, the ambiguities are there, as a current licensee, that's what's making it harder for me to totally accept your argument. I certainly understand it, but this is not somebody who's not been before the board before. This is not somebody that already doesn't have a license. This isn't somebody that's already been manufacturing. And so that's part of the concern for me.
Thank you, Mr. Jones. And if I could respond to that, I think you raise a few very good points. And to begin, I think that the experience of an applicant, and regardless of how many licenses they've been a part of, if the activity is legal under the statute, their experience doesn't matter, right? So that's one way of looking at this. If what he did is permitted under 1738, I think it's case closed. But to get at the other points you raised, that yes, this is someone who is very familiar with the regulations, and as we explained in the letter we provided yesterday, Mr. Insko believed he was acting in accordance with what is permitted. He, with his prior, the prior facility that he was involved with, they had inquired as to whether this testing the equipment when they were in delegated status was permitted. That was about a year ago, and we provided some documentation to help support that was a legitimate belief. We acknowledge that this is a slightly different situation because they're not in delegated status yet, and over the passage of time, that fact, which is an important fact, that fact was lost. But again, I think this illustrates someone who has tried to act in compliance with the regulations and was basing his current belief on prior contact with the regulators to get guidance on what could be done, and that goes to this question of whether there was any bad intent and whether there was just total disregard for the regulations. So I understand your point that this is someone who is familiar with the regulations, but again, this is a little bit of a gray and ambiguous area.
I guess my second point to this is, as I understand the memo, and you don't really speak to that in any of your responses, at least as I had read them, was that I guess staff found this out because it was posted on Facebook. As a licensee, in terms of understanding advertising and understanding marketing and some of the rules we have, for an unlicensed individual to be putting on Facebook product that he's manufactured in an unlicensed facility, one that hadn't even been approved yet, not even in delegated status, sort of goes beyond the pale of Mr. Springer's question, of somebody, well, have you made a batch of your Italian vinegar dressing infused with marijuana? Well, you can do that in the kitchen where it's grown. You know, these are processes that are pretty sophisticated equipment that I assume one generally wouldn't have in their kitchen. So I'm not sure where I fall. I'm just letting you know what I'm thinking in terms of how I'm looking at this and listening to your response and knowing the history of this particular applicant, having been before. And I've appreciated its very straightforwardness in answering a lot of the questions. It gave me good information at the time and helped me understand. But just, you know, not a rookie.
And thank you. Just one last comment on that. You know, Kate reminded me that one of the, you know, the reason why this came up is that this was a manufacturer, new equipment, and while he did have experience in the previous facility, it's a different process, different equipment, and that's why there was the need to test it now, and he couldn't just rely on the prior experience.
Mr. Chair, two things. One, when manufacturing applicants have talked to us about needing to test their equipment, we advise them that they need to test it on a non-marijuana products such as lavender, extracting lavender oil out of lavender. So there are options for testing this equipment that don't use marijuana. The other issue is this kind of melding of personal use and commercial use, and that takes us down a road that is incredibly troublesome and has a lot of potential for confusion and you know, what happens if a licensee doesn't have some plants tagged and say, oh, well, that's my personal grow? I mean, I don't think the board wants to go there. So I think if the board hasn't already, and perhaps this was done before my tenure began, but the board, I think, needs to be very clear, be my recommendation, that the board be very clear that personal grow and commercial operations, including commercial facilities, need to be kept very separate.
And I think that question has at least come up tangentially over the last couple of years, and I think we've been pretty clear. I mean, we've seen the results of you know, in-house consumption of products on licensees. So your point is very very well made. Yeah, how come you didn't just try to make some lavender oil? I mean, I can understand that this is advertising. The location, this is an entirely new location, correct? It has never had a license of any sort.
Correct.
Okay, and what licenses are you involved with right now?
None. No, I'm completely off of
You're license free.
License free.
All right. Yeah, no, I'll like I said, you know, they say there's no such thing as bad publicity. Well, obviously, sometimes there is. You know, and did you call? It's in here. You called and asked enforcement about.
I can speak to that, and I want to just clarify that what we have, you know, when Kate was contacted by enforcement about this, he was very surprised because he believed he had been acting on guidance he previously received, and I asked him about that, and when Kate was involved with a different licensee, they had inquired their attorney as to whether or not they could test the equipment using marijuana, and the response that they got back was that it was permitted, and we spoke with their attorney, and you know, they said, you know, this was a year ago. I don't have any notes. I don't have a written response. But we were able to track down a billing statement where she noted the conversation with enforcement and that the guidance was to the applicant. So he felt comfortable relying on that in making this decision.
All right. Okay, I don't want to beat this up. Does anybody have a motion preliminary to or with regard to the recommendation of the director?
Yeah, Mr. Chair,
go ahead.
So I would motion that the fine be upheld with $3,750 suspended, pending that with over the course of 1 year from licensure that the applicant not receive any notices of violation pertaining to advertising or metric tracking.
Okay, is there a second?
I'll second.
Okay, any discussion? Mr.
What was the actual dollar amount again?
So it would be the fine would be upheld, but there would be $3,750 suspended.
That's what I wrote down. I just want to make sure.
Okay, yeah, so it would be 75% of the fine would be suspended. And so, and my justification for this is that the applicant does have experience. The optics are poor, but I don't believe there was any nefarious intent here. Reading through the Facebook post is obviously saying he bought the marijuana from a legal, regulated establishment. The amounts that he was displaying were very small. There was no offer for sale or personal message me or anything of that nature. So I think that the $5,000 itself is steep, but that it should be an incentive to act responsibly going forward.
Miller.
I can't support the fine, basically because it's still unclear to me exactly what regulation was violated. So I'm not positive that unless the director could specifically tell me what statute was or regulation was violated, as Mr. Springer said, we've talked to several folks, and they say, yeah, we've been making this in the kitchen, and it looks great, tastes great. They're definitely not selling it, so I'm not positive what we're giving a fine for.
Through the chair, Mr. Miller. So I don't particularly remember you asking people whether they had made these products in their facility before, and we're certainly not aware of anyone using their manufacturing facility to manufacture before they were approved by the board. So AS 1738-070C, notwithstanding any other provision of law, the following acts when performed by a marijuana product manufacturing facility with a current valid registration are lawful. 1, packaging, processing, transporting, manufacturing, displaying, or possessing marijuana or marijuana products. This was advertised on Facebook under Cold Creek Extracts, which is the name of a potential licensee. It was done at a potential licensed premises. So in the sense that it wasn't done at the place where the marijuana was grown, there is ambiguity in that, but because this was all for the purposes of becoming a manufacturing licensee, in my opinion, it violates that section of statute.
Can we speak to that real briefly?
Sure. Briefly,
yeah. Again, I think we are in a situation. We have a common law system for a while, for a reason. Sorry, we've had it for a while, and we have it for a reason. And as we've seen over the last couple of years, a lot of us have been intimately involved with working on the statute that is in place and crafting these regulations and interpreting them. It's very, very difficult to capture the practical realities of an industry completely in the regulations and the statutes, right? There's always a little bit of, for lack of a better term, some wiggle room, some gray areas, and that's why we have judicial interpretation of our statutes and our regulations, or board interpretation. Right? I just want to clarify here that this is a situation where I think there's there's confusion and ambiguity. The director is mentioning that Cold Creek is a potential licensee. The statutes and the regulations don't put any requirements on potential licensees. We understand that the optics are not good. We understand it's a bad look. We understand that considerations of licensure say, how has this person been acting and behaving? Some of the things that you look at are criminal background history, right? So those factors do weigh into the licensing decision. But if you had a warehouse that was not licensed, or you had not submitted an application, and you were manufacturing a personal amount of marijuana, which I argued earlier is permitted under the statute, and then you submitted a license application, does that automatically mean that activity is not permitted? The facility is not licensed yet. It's not delegated. So I think this can be analyzed under the personal use statute. Given the fact that there is this confusion, I think we're headed for a situation where we need some clarity, we need some guidance. We don't have we just got, this was brought to our attention that there was a problem last Thursday. We met with enforcement the very next day. We got the directors, I spoke with the director on Monday, we got the director's memo on Tuesday. I provided you with a response on Thursday. It's now Friday. It's moving very quickly. We haven't had a chance to really thoroughly analyze and provide a solid legal analysis of the statutes and the regulations other than what we're going through orally here. Given this confusion, I think that it's certainly troubling to us to hear discussion of a pretty significant fine. Even with 75% held in abeyance, that still is a significant fine. And it's particularly concerning, I think, when we look at some of the fines that were suggested and then levied just yesterday. We have, the board considered individuals that I think acted outside of much more clearer guidance and clearer direction from the board, and in those cases they were similarly had the same percentage of the fine, I'm not sure what the term is, but waived or held, suspended, thank you. And I feel like we have a situation now where we have someone who has displayed nothing but, good faith. Right? We have evidence to support his state of mind, which is that he previously talked with enforcement, tried to get guidance on this, hasn't committed any other infractions, was testing the equipment, and given the fact that this is someone who is familiar with the regulations, has been involved with this for a while. This is the first time there's been any sort of an issue. I don't think it's fair to hold this applicant to the same standard as some of the other people who more clearly violated some much more serious aspects of the regulation. So we would argue that the fine should be, I think the fine should be waived. I think the sort of distraught and time and effort that's gone into reviewing this is penalty enough. And furthermore, this is, again, an opportunity for a public discussion about this and a chance to provide some more guidance to other people in this situation about what they can and cannot do.
Okay, thanks, Mr. Brandeis. On debate, I'll say that Mr. Inshu is currently not a licensee. The premises that he manufactured on is not a licensed premises. There's no indication, either from the photographs that appeared on Facebook or anything else, that he manufactured any much more than what appeared in the photographs, which certainly falls under the legal amount for personal possession. Manufacturing, by dint of the definition of accessories, by a private individual, by a non-licensee, is legal. It doesn't matter where they purchase the marijuana from, whether they buy it from a store or whether they grow it themselves or whether somebody legally gives it to them. So I'm just not convinced that we're even on good enough ground to issue a suspended fine, partly because there's a possibility that it would be appealed. And if it is appealed, then it's going to cost both of us money, and there's no telling what the outcome might be. Sometimes appeals are okay because things get settled. The issue at hand is kind of confusing, and we'll have to deal with it. So,
Mr. Chair.
Yes, sir.
Mr. Brandeis and my fellow board members do make some good points. I know all votes or all motions fail upon a tie, and so I'll withdraw my motion.
Okay. Is there any other motion? Go ahead, Mr. Jones.
I don't know about a motion, but if there is ambiguity, which I certainly feel there is, there are two ways to remedy it. One is lengthy, and then you never know what you're going to get, legislative process, and the other is to take an action that you assume will be appealed, and maybe on appeal, common law becomes, I don't know what the legal term is, but more judicial law than the common law, and we get a judicial ruling. Now, I don't know that, putting in a fine of $1,000 and then attorney fees on top of that is the way to get this case before the judicial system. That's harder to do, and then that's costly. But simply say we shouldn't do anything because of the ambiguity, and we don't know what we're going to get when we go to court. You don't know what you're going to get before you go to court. You don't know what you're going to get when you propose something to the legislature and they change it 180 degrees on you, which happens all the time. So either way, we're going into a zone, and I understand that a motion is not going to pass to levy a fine, but not knowing the outcome of legislative or judicial is not a reason not to try to uphold the law as we interpret it. And I would lean more toward the interpretation that the directors put forward than what the applicant has put forward.
All right. Thank you for that.
Mr. Chair, I'd like to make another motion.
Go ahead.
Unless there's any further discussion on the matter of the fine. There's no more discussion on that, then. All right. I just closed all my files. Oops. Okay, Mr. Chair. Motion to approve license number 155.
Building, looks like.
Correct. There's another retail facility and potential cultivation that is licensed. They're just going through the permitting process.
Okay, whereabouts in town is that?
1 block west of King Street. No, east, sorry.
Okay. Neighbors are all happy to see you in there?
Actually, yeah.
Okay. Are there any questions on the general application? Because we do have some products in here to go back. How many products do you have on here?
There's 12.
You got some edibles and some...
Just one edible product. The can of caps are the only edibles.